Peace, family. Hope all is well. All right, family. Today I want to talk to you guys about contract damages and remedies. And do not forget here, okay, my Patreon link, okay, in my bio. If you become a member there for free, you will have access to this PowerPoint as well as the presentation as often as you like as a reference point. But first, a disclaimer. This is not financial advice. This is not legal advice. If you are seeking legal or financial advice, I highly encourage you to seek legal or financial counsel immediately. Let's get into it. Today we'll discuss, okay, ways you can be damaged by contracts and the remedies available to those damages when there has been a breach of contract, fraudulent or deceptive practices, unfair terms or predatory clauses, as well as failure to provide full disclosure. Starting with our breach of contract, all right? What is it? A breach of contract occurs when a company fails to deliver on its obligations as outlined in the agreement, okay? Whether by not performing, delaying performance, or performing inadequately, all right? Examples: a furniture company guarantees delivery within 7 days but delays for months without valid explanation. Second, a home warranty provider promises to repair appliances within 48 hours but repairs take weeks. And thirdly, a contractor leaves a renovation project incomplete despite receiving full payment. How are consumers damaged by that? All right. Financial losses first, okay? Paying for services/products that are incomplete or below standard. Secondly, opportunity costs, missing out on an alternative solution or contracts due to reliance on the original company. And thirdly, emotional distress, stress caused by unmet expectations, particularly with essential goods or services, and how you would remedy that. All right, first, specific performance. Ask the court to compel the company to fulfill its obligations. All right, second, compensatory damages. Seek monetary compensation for direct and consequential losses. And thirdly, contract termination. Cancel the contract and request a refund for any payments made. All right, family, and protections under the UCC here, okay? So our first, seller breach, all right? We will have our relevant sections of the UCC, and you can read this here by looking at it, UCC 2-601, okay? So for number one, delivering defective goods, failing to deliver on time, refusing to replace non-conforming goods. Those are your relevant UCCs right there that help you with that particular situation. Number two, a lessor breach, okay? Providing defective or non-functional leased goods. Failing to perform repairs, you have the relevant UCC codes to assist, all right? And your lender breach, all right? Mishandling collateral or providing inaccurate account information. You have your relevant UCCs there. Let's continue. Our fraudulent or deceptive practices, okay? What is it? When a company misrepresents or conceals material facts to mislead a consumer into entering a contract. Are examples of that here, okay? First, a car dealership rolls back odometers to inflate a vehicle's value. Secondly, a subscription service advertises a free trial but hides auto renewal terms in fine print. And thirdly, a loan provider promises a low interest rate but fails to disclose balloon payment clauses. How are you damaged by that? Okay, firstly, overpayment. Consumers pay more for products or services than they are worth. Secondly, unrealized benefits. Products/services fail to perform as advertised. And thirdly, financial harm. Hidden fees or escalating payments lead to unmanageable cost, which brings us to our remedies, okay? First, you can use rescission, okay? Cancel the contract and demand a refund. Second, okay, punitive damages. Seek additional compensation to penalize the company for willful misconduct. And thirdly, regulatory action. File complaints with agencies like the FTC or State Attorney General. Which brings us, okay, to how it's covered by the UCC, all right? False advertising. An example of that, a seller misrepresents the quality or origin of the goods, and those are the relevant UCC codes to assist with that. Second, failure to disclose material facts, okay? An example is a lender hides unfavorable terms in a secured transaction. Here are your relevant UCCs to assist with that. Thirdly, forgery or alteration. Example, a fraudulent endorsement on a check, and you have your relevant UCCs for that. And fourthly, deceptive warranties. Example, selling goods as is, okay, without disclosing known defects, and your relevant UCCs are there. Let's continue. Unfair terms or predatory clauses. What is it? Contracts with hidden or unreasonable terms that place an undue burden on consumers while protecting the company. Examples of that, okay? A gym contract requires a 12-month minimum commitment with exorbitant cancellation fees. Second, a payday loan agreement includes an APR of 400%, trapping the borrower into a cycle of debt, okay? And lastly here, a software license agreement prohibits refunds for defective products. How are you damaged by that as a consumer? Okay, you have loss of freedom. Consumers are locked into agreements they can't easily escape. Next, we have excessive fees. Hidden penalties drain financial resources. And lastly, imbalance of power. Companies exploit their superior knowledge and resources. Our remedies for that, okay? First, we have our unconscionability defense, okay? Argue that the terms are so unfair that they should be voided. Next, class action lawsuit. Join others with similar claims to challenge predatory terms. Okay, and lastly here, arbitration challenges. If forced arbitration is unfair, challenge is enforceability in court. Which brings us, okay, to the UCCs here. Okay, first, your unconscionable terms. An example of that is a contract requires consumers to pay exorbitant fees for canceling a service, okay? You have your relevant UCCs to assist with that. Next, hidden warranty disclaimers. An example, okay? Fine print excludes all warranties on a product, even if defective. You have your relevant sections under that. Third, excessive default penalties. Example is a lease agreement imposes penalties for exceeding the actual loss caused by late payments. You have your relevant UCCs to assist there. And lastly, predatory loan terms. An example is a secure transaction includes clauses allowing repossession after a single missed payment without notice. And you have your relevant UCCs there. Let's continue. 2, failing to provide full disclosure. What is that? Okay, a company omits key details about the product, services, or contract terms, preventing consumers from making informed decisions. And examples of that is a landlord doesn't disclose additional move-in fees until after the lease is signed. Second, a credit card company fails to explain interest rate increases triggered by missed payments. Thirdly, a retail hides restocking fees in its return policy. Let's continue. How are consumers damaged? Unexpected costs. Hidden fees or penalties increase the financial burden. Next, poor decision making. Consumers may not enter the agreement if they knew all the details up front. And lastly, a legal disadvantage. Omitted information can lead to disputes where the consumer appears uninformed. Let's continue to our remedies. All right. First, we have our breach of duty. Sue for failing to disclose material facts required by law. Second, void the contract. Cancel the agreement on grounds of insufficient disclosure. And lastly here, consumer protection claims, okay? File complaints with agencies like the Consumer Financial Protection Bureau, the CFPB. Let's continue to how it's addressed by the UCC. All right, first, right here we have sales misrepresentation. Examples is selling goods with hidden defects or understating their quality. And you have your relevant UCCs to assist. Okay, second, your undisclosed fees or charges. All right, your example. A lender fails to disclose additional fees associated with a loan, and you have your relevant UCCs to assist there. All right, next, warranty disclaimers in fine print. Example, okay, a retailer hides a clause waiving the implied warranty of merchantability in small print. All right, and you have your relevant UCCs there. All right, and lastly here, we have collateral handling in secure transactions. The example is a creditor sells collateral without informing the debtor of its value or sale process. And you have your relevant UCCs to assist with there. All right, family, I know it was kind of expedient, but you can slow it down as you do your replays. If you do, follow the Patreon here, click on the link in the bio, become a member for free through that link so that you can enjoy more presentations such as these for free, as well as the PDF file that holds this presentation with the slides. All right? More food for thought, okay, under the contract damages and remedies that you can utilize for those damages, family. All in all, I hope this helps, and I love you guys. Peace.